Hello, students. Let's begin with Chapter 2. I will be going quickly through these PowerPoints. I do indeed hate PowerPoints, but this is the quickest way to get through the information now that we've been compressed from 16 weeks into 8. So I'll ask you on your own to read through the PowerPoints and, time permitting, the text. For example, if you're going through PowerPoints and don't understand a concept, I would then look it up in the text for further explanation. You may frankly not have time this semester to read all the text assignments, and I understand that as long as you understand the concepts. Okay, so there will also be YouTube videos in here that I will ask you to pause this recording and then go to your outline. You'll receive outlines of these lectures. But if you go to your outline and click on that hypertext link and watch the video and then come back to this, I think you'll find it very helpful. I've selected those that do a good job of explaining certain concepts. All right, the first concept is judicial review. And basically, you may recall that there are 3 branches of government: executive, legislative, and judicial. The executive, basically, Senate and House, and they'll pass laws. The executive will be the president, and he will either sign or veto law. If he signs it, it becomes law. However, that's not the last word. That law may well be set aside if it's not constitutional, or in other words, it's unconstitutional. So who has the right to say that ultimately? So in other words, who has the ultimate authority over laws in the United States? And that is the judiciary. In the state system, it's the state courts and ultimately the state Supreme Court, whatever state you're in. And in the federal system, especially if it has to do with the U.S. Constitution, it'll go through the federal courts, up through appellate courts, then ultimately possibly up to the U.S. Supreme Court. Let's talk about jurisdiction now. That's another judicial concept, another legal concept. And jurisdiction basically is a fancy word for authority. It basically means, does a court have authority over the case? Now, there are different types of authority over the subject matter, over the person or company, et cetera, et cetera. So let's go over those various types of jurisdiction. In rem jurisdiction, or jurisdiction over the thing, let's say, for example, that I was suing you over, or let me back up, 2 people from California were suing each other over property in California. A sale of land in California went wrong. Well, a court, if they tried filing a lawsuit in Oklahoma, the judge would dismiss it, saying we, Oklahoma courts, do not have jurisdiction or authority to hear cases about California property. Go back to California and file it there, because California has that in rem jurisdiction. A very important concept is in personam jurisdiction. Now, the easy way to remember this is personam, or person. Even if the court has jurisdiction over the subject matter, can the court reach the people or companies? Keep in mind, a company is a legal person. So that's a way to remember in personam. Does the court have authority, in other words, jurisdiction over the person? Now, how do you determine that? How would we in Oklahoma, as a court, have jurisdiction over those people in California? Well, 2 concepts are basically long arm statutes. Every state will have what's called a long arm statute, and almost every country will have an equivalent as well, by the way, where essentially, what must somebody prove in order for the state, in this, our example, the state of Oklahoma, to reach their long arm of the law and drag people all the way from California back here. So remember that visual. Long arm of the Oklahoma court is dragging you all the way back here to Oklahoma. And that's a concept called personal jurisdiction. In order to assert personal jurisdiction under the long arm statute, there had to have been the person being dragged here into Oklahoma must have had some minimum contacts with the state of Oklahoma. In other words, they cannot be a total stranger to this state. So I'll ask you to pause this now and go view these 2 videos about personal jurisdiction and minimum contacts. Welcome back. You've seen just about contacts, minimum contacts with a state. If it's a corporate person, a corporation, company, any type of company, limited liability company, they usually can be subject to personal jurisdiction wherever they're incorporated or formed, where their principal office is, but also wherever they are doing business. So let's say that you start a mechanic shop, a car repair shop here in Tulsa, Oklahoma. If you just repair cars here in Tulsa, it's unlikely that a person in Florida could sue you over a faulty car repair here. It's difficult for them to prove you have done business in Florida. However, if you happen to be do a lot of business via the internet and you're based in Oklahoma, and you happen to sell product into all 50 states, including Florida, then you would understand how a court there would presume to have authority to drag you into Florida in a lawsuit pertaining to the specific sale into Florida. Let's say Tesla moves here to Oklahoma, manufactures cars, and ships them to Florida. Well, theoretically, somebody in Florida could sue in Florida because they would say, Tesla, even though you made the car in Oklahoma, you sold it into Florida. Here's the minimum contact. You can see some various examples of why do they advertise, do they do this, et cetera, et cetera. Now, subject matter jurisdiction is a third type of authority or jurisdiction, and that usually means, do I as a judge have authority over the type of case? First, we talked about property. Second, we talked over a person or a company. Now we're talking about what's the subject, what's the topic? Well, for example, if you go down to the Tulsa County Courthouse, some judges will be hearing domestic cases, adoptions, divorces, etc., child custody. A different judge will be hearing just general lawsuits between companies, between individuals. A different judge will be hearing criminal cases where like your speeding ticket or something like that. So that's a subject matter jurisdiction, and the courts will be divided up into hearing a different subject matters. Let's unpack that a little bit. Some courts are also general jurisdiction. For example, when you go to the general civil court, they can hear many, many different types of cases where two companies or two people are suing each other, or a company suing a person. You didn't pay your house payment, the bank is going to sue you. They would go to one of these courts of general jurisdiction. The court of a limited jurisdiction, again, which just talked about, they can only hear the specific type. Or another example is small claims court, limited jurisdiction. In most states, there's a separate court for people that are suing for under, I can't remember what it is in Oklahoma right now because it changes year to year, but let's say 7,000, 7,500, something to that effect. If you're suing somebody for that, you don't have to go up to the general court and spend all that money and all the lawyers' fees. You can go to a simplified court where a lot of people don't even have lawyers, and that would be a small claims court. So that is an example of a court of limited jurisdiction. I'll let you read that on your own. Subject matter, we talked about. Now here's another jurisdiction. Again, we're taking this pie and then we're analyzing it in 20 different ways or many different ways. Another way to think about jurisdiction is, down here on the bottom level are all these courts of original jurisdiction. They are the first ones. They're the original court to hear a case. So if you're going to sue me because I run into you in a traffic accident, we're going to go down to Tulsa County Court, and you will sue me in this court of original jurisdiction, which also happens to be a civil court, which also happens to be a court with a subject matter of civil. So you can call this court different things. Original jurisdiction just means level when you're thinking of level 1, 2, 3 going up. Now, courts of appellate jurisdiction. If I lose, and we're going to cover this more a little bit later, but if I lose in the lower court, the court of original jurisdiction, then I might have an authority to appeal it to a higher court. That's known as a court of appellate jurisdiction. They only hear appeals. They don't hear all these lawsuits that get filed originally. They only hear the few cases where it actually goes to trial and somebody appeals it. A very small percentage of the total cases. Now, let's get back to subject matter, and I'm sorry these PowerPoints jump around a bit. They're from the textbook publisher, so I apologize. I don't like the sequence. Nevertheless, within the state of Oklahoma, there is two, and within every state in the United States, there are essentially two authorities that have courts. There are the feds or federal, and there are state. So, for example, in this traffic accident, you'd probably sue me in a state court of general jurisdiction, a state civil court. That's probably where you'd sue me. However, let's say that I'm a jailer, I have you in jail, and I violate your civil rights under the U.S. Constitution. Well, if that's the case, you can actually sue me in federal court because you've sued me about a federal question. So that jumps you into federal court if you want, okay? So if it violates the Constitution, a federal statute, et cetera, you'll go to federal court if you want. You have that choice. Also, the Fed said, you know, we don't want people from out of state to get hometown treatment or home court favoritism, however you want to call it. So we, the feds, are going to set up in our federal court system a fairness court, if you will, or we're going to ensure that it's fair, because if someone from two different states, the guy suing and the guy being sued, are from different states, and the amount is over $75,000, we'll let you come into federal court. And the thought there is, gee, I'm not in front of a state court judge, I'm in front of a federal court judge. He's a lifetime appointment. He doesn't have to be elected or re-elected by people in Oklahoma. So I'm coming in from Florida to this lawsuit, and I got sued by somebody from Oklahoma. So I'm gonna move the case to federal court because I want to make sure I get fair treatment by a judge that has lifetime tenure, and there's less chance, or at least the appearance, of favoritism. I'm not saying that necessarily happens in state courts, but that is the concept, that make sure we have treatment, fair treatment for people and companies from out of state. Here we go. Again, many of these adjectives we're using, many of them may apply to the same court. So I apologize, but jurisdiction, fancy word for authority, just has many different meanings. Another one is exclusive jurisdiction. Another one is concurrent jurisdiction. So we just talked about you suing me. Two courts could hear that. You could, if it's over $75,000, you're from Florida, you could either sue me in Tulsa County, or you could sue me in the federal court in Oklahoma, which happens to just be across the street, but a different judge's different system. So that's known as concurrent jurisdiction. You could go to either court. Exclusive, you can only go to one. For example, if you file bankruptcy, you have to go to bankruptcy court, a federal court. You can't go to a state court. You have to go to a federal bankruptcy court. I'll let you look through that. We've explained cyberspace. That's the same thing. Essentially, this is what we talked about businesses when contacts. And the question is, well, wait a minute. If you're on the internet, you're not only in every state, you're around the world theoretically as a business. So couldn't you be sued anywhere? Well, most courts have basically set up this sliding scale of, is it fair for you? Okay, each of you pretend you're an Oklahoma business. Is it fair to you to be pulled into this foreign state? Yes or no? Well, if you just have a passive website you set up in Oklahoma and anybody in the US or anywhere can see it, it's probably not fair for them to drag you in. On the other end of the spectrum, if you have the website in Oklahoma and you're selling consistently to customers in Florida, then it may well be fair for someone to sue you in Florida. Now, and then in between, there's a gray area where judges will look at the various factors. Well, I've only made one sale, or I did advertise in Florida, or I didn't advertise in Florida. And they'll look at these various factors and then decide which is fair, yes or no, whether a Florida judge, whether it's fair for me to be dragged into Florida in this case. Venue. Jurisdiction means whether the court has authority to hear something. But I think we've already talked about concurrent jurisdiction. There may be various courts where that could hear this case. So, for example, you're a business in Tulsa, Oklahoma. I'm a business in Oklahoma City. I'm suing you. Probably either court, either in Tulsa County or Oklahoma City, or Oklahoma, the county of Oklahoma City is located, either one could have authority to hear it, but a judge would probably consider, where are most of the witnesses? Where are the documents? So in other words, for the court, which is the fairest location for us to hear the case? The fewest witnesses have to travel, the fewest lawyer travel, the fewest, all these things a judge can consider and then decline to hear the case or say that it's proper to hear the case in that judge's courtroom based on venue. Another concept is standing to sue. Now, do you have a right to sue me? And you basically have to prove three things. You can't, I mean, our news stations now have just, everybody over here says everybody over there is bad and vice versa. And we get angry and we see things and we get up in arms and righteous indignation or whatever you want to call it. But does that mean you have a right to sue somebody over something? Well, you have to prove something. First, you have to prove I am individually harmed. What the other person I want to sue has done caused it, known as causation. And number three, the law provides a remedy. So if I was harmed, that I want to sue you, you caused it, I also have to prove, does the court give me a remedy or a cause of action to sue you? Okay, so I'll let you pause and then go to watch this YouTube, which explains a California case where there was a question whether regular citizens had standing to sue somebody. All right, welcome back. This is the federal court system. Is kind of a good way to give you a graphic of the various types of courts. First look on the left. That's the easiest to understand. You see the original jurisdiction courts are on the bottom left. The most common one is the U.S. District Courts. So here in Tulsa, somebody from out of state, you might sue somebody from out of state in federal court or vice versa. If you lose, you have the right to appeal to a court of appeal. And if you lose there, you have a right to appeal to the Supreme Court of the United States. Now, some cases can go all the way to the Supreme Court of the United States from your state court. If you look on the right, it's similar on the right. There's basically 3 levels or 4, depending on if you're for example, a small claims court, etc. But basically, you can go appeal, and then if there's a federal question, you could go all the way up to the federal Supreme Court out of state court. You do have some limited remedy there. Right, we've already talked about that, that. We'll keep going. Now, here's a nice chart which shows the circuits. So this is federal system. So you see the state of Oklahoma there. You see little W, N, and E. That means within the state, we happen to have three federal courts. But if we appeal from our federal district court in Oklahoma, we go to the 10th Circuit. The 10th Circuit will hear all cases in the states of Utah, Wyoming, Colorado, New Mexico, Kansas, or Oklahoma, the federal cases, that is. And then if you lose there, you would appeal back to D.C., the Washington, D.C. U.S. Supreme Court. I'll let you read through those, and I'll let you read through the Supreme Court. Certiorari, make sure you know certiorari. Okay, now we're going to jump into alternative dispute resolution. Litigation, it's time consuming, it's expensive, and it's public. So for example, if I'm suing you're getting divorced, well, you probably don't want your finances in a public record. If you're a company and someone steals your trade secrets, you probably don't want to sue them in public court. You might be able to get a protective order, but that's a little difficult. You might not be able to get a protective order where the judge seals the record. But a way to bypass that is to, instead of dispute resolution via litigation, which means in the court system, you can do a private alternative dispute resolution. These are known ADR sometimes. There are basically three types: negotiation, mediation, arbitration. Negotiation is just informal. Either the business persons, the individuals, and or their lawyers sit down and they just try to reach a resolution on their own, voluntary, and then dismiss their claim against each other for payment of money, no payment of money, just spend whatever you come up with. Now, mediation is another form of alternative dispute resolution where it's a tad more formal. You hire both people, the people that have a dispute, they hire a mediator who basically is a person that has, as we say in Oklahoma, no dog in the fight. This person really doesn't care per se which way this comes out. They're just hearing the case for the first time from both of you, what the dispute's about, and for example, they might have you both in the same room. Like, you give an opening statement, then they'll put you in separate rooms, and they'll go into this room and say, hey, if this guy sues you, you're going to lose, and you got to come up with some money to settle this. Then he can go back into the other room and say, hey, I know you want to sue them, but you might lose because here's your weaknesses in your case, and here's their strengths. And they'll slowly try to move the two parties. They'll go back and forth. He or she will go back and forth and try to move those two parties towards the middle to see if they can get a voluntary agreement. And keep in mind, these three alternative dispute resolution methods are confidential, less expensive than litigation, and not as time consuming as litigation. They're faster. Now, with arbitration, it's a little more formal. You hire an arbitrator, or you could have a number of arbitrators, but basically it's kind of like a mini trial. You'll submit your evidence, you'll submit a brief, and you can either have literally a hearing and take witness evidence before him, the arbitrators, or you could just submit it on the briefs, depending on what you decide. In other words, the documents, and then the arbitrator will actually come out with a decision, the arbitrator award. It's binding. It's as binding as a lawsuit case, as a judicial declaration, a judgment. A lot of commercial contracts have a mandatory arbitration clause. Courts often uphold them. There are some instances where they don't. One that's been a really big sticking point is when you have a credit card. If you look at your debit card or credit card agreement terms, there's probably a clause in that where you, maybe unknowingly, have agreed that if you have a dispute with a bank or credit card company, you will go to arbitration instead of going to court. So that's an arbitration clause. I'll let you read the arbitration statutes, issues. There are three other types of alternative dispute resolution. we'll just cover them real quickly. You're not going to, it's rare that you would see these. You have someone that's a neutral, just look at the case and make an evaluation for you. You could actually have a mini trial without the other side if you want, and put on your evidence. Let's say, for example, your own lawyers would put on your evidence, and then from the same law firm, your lawyer might fight for the other side just in front of some test jurors, some jurors that you hire, and then let you them come out and see the way that they do it. So there's a little bit different, but summary jury trial is another method. I won't bother you with the dispute resolution organizations, etc. You can read that on your own. International, also, in international contracts, we often put a forum selection and choice of law. Those are two different things. So if you're doing any international business, and frankly, most of when you're in business, when you're business leaders, pick up a contract or make sure you read these contracts. And by contract, I mean, it could be a purchase order coming to you, or it could be you just issuing a purchase order to another company. That's a contract. Probably, hopefully, in the terms and conditions, it will say if there's a dispute about this purchase order, for example, the law of Oklahoma applies, for example. But that doesn't mean you'll hear the case in Oklahoma. That just means that the judge will look at Oklahoma law to decide it. Forum selection would mean, and we agree we're going to hear this case only in Oklahoma, for example. So be careful when you read those contracts. They may have forum selection of a specific country, or you might have arbitration in a neutral site, etc. So that's important in your contracts to make sure you know what it says. All right, let's jump on to Chapter 3, Court Procedures. All right, basically, we've talked about alternative dispute resolution. Let's say that didn't work or you didn't want to do it, so you're going to go ahead and go to litigation. You're going to go ahead and sue somebody in court. Well, one way to look at the stages or chronology is pretrial, trial, post-trial. So I'll let you look at 3.1 here. This is kind of hey, this is a circle. These are the things that happen. Let's say there's a traffic accident, and then I hire a lawyer because you hit me, and then I file a complaint and serve it to you, have a process server give it to you. Your lawyer files an answer. We do a bunch of discovery questions back and forth, and then we ultimately have a trial. When you hire an attorney, some attorneys will do fixed fee. For example, if you're having a will, have a lawyer write up your will. Often they'll just do that for a fixed amount. If you're doing litigation, most attorneys, it'll be hourly or contingency. If it's hourly, it's a specific rate, and that's could get very expensive because, to a great extent, you don't have control, nor do your lawyer, over how many hours it's going to be through trial. I mean, the other side is going to control that as well, the person you're suing or the company you're suing. So hourly fee that the lawyer will literally charge you. Now that varies dramatically from state to state, city to city, country to country. You can get a lawyer in Oklahoma for, a couple $100, $250 an hour, an average firm. And if you go to Houston, that's probably going to be $350 an hour at average. If I want to hire lawyers in New York, it's even higher than that. So it just depends on where they are. Contingency fee, that simply means, I think you see those guys on TV that say, hey, if you lose, you're not out anything. Essentially, that means you have a case, you bring it to a lawyer, and he says, okay, this is what we're going to do. If I win for you, I get 33% or 40 or 50% of everything you win. And the theory there is the attorney is also taking a risk because he's taking a risk in all his time by not billing somebody that's paying him hourly. He's giving up money, but he's hoping to make more at the end on a contingency. So sometimes a contingency case makes sense for both of you and the lawyer. Settlement considerations, should you settle if you get sued? Well, obviously that's a question of how much money am I going to spend going forward? You know, do I or my company have the time to dedicate to this? Is there a nuisance value that I can just get rid of this by paying X amount? Now here we go with the litigation. It's explained well in this YouTube, which it just happens the state of Oklahoma has a few different steps than Michigan does, but this is a good video I found from Michigan that explains the chronology. So I'm going to ask you to watch this to give you a good idea of an overview of how a case actually proceeds. And again, this is not criminal. This is a civil case. In other words, it's not you've been arrested and a judge or jury is going to try you for a criminal conviction. Everything we're talking about today has to do with a person suing a company, two persons suing each other, et cetera, et cetera. In other words, civil litigation, not criminal. So go ahead and watch that video now. All right, as you saw in that, the pleadings really, you're suing somebody, you're going to put out a petition or complaint. They happen to call a complaint a petition in Oklahoma in state system, not in federal. They call it a complaint. In most states, it's called a complaint. And I have to say that the court has jurisdiction. I have jurisdiction over the person, in personam, etc. I have to then give my legal theories. I'm suing you for a breach of contract, or I'm suing you for your negligence. You ran into me with your car, you're looking at your phone. And I have to also set forth what the remedy is. Under the law of Oklahoma, I'm entitled to you paying me all of my medical bills and fixing my car. So that's the remedy. Now, I have to serve you, or more accurately, I have to have like a sheriff or a professional process server actually deliver to you the complaint and a piece of paper called the summons that a court issues. And that just basically on the process server say, yeah, I took this to the defendant's house, his business, I gave it to him, and he signs it and brings it back to court. That's an example of a complaint. We talked about service. If you don't answer, I can get default judgment. Here's the summons. So here's the service of process. Here's an example saying, hey, I served this person at this time, this date. I'll let you read through how one can provide service. Answer, once I've been served, I better answer. I'll have 20 days, 30 days, 40 days, depends on the system and the state, but I've got to file an answer, or you can just get a judgment with me called a default judgment against me if I don't answer. I have to, your complaint that I've received when you've sued me, you've actually written it in numbered paragraphs, like Shakespeare or the Bible, where each paragraph might have a number with it. Well, I have to answer every number, every paragraph, and admit or deny it. I also will say what my defenses are. You say I'm negligent. No, you were negligent. I wasn't negligent. Or I already paid you for this. So those would be my affirmative defenses, examples. Counterclaims. Let's say that you hit me, I sue you, saying, hey, you ran into my car. But let's say, for example, I had jumped out of the car and started beating on you and you had to go to the hospital. Well, then you would have a claim back against me for your hospital bill, for me assaulting you. Yes, I'd probably be criminally liable, but you could also sue me in a civil court for battery, assault and battery. So you would have a counterclaim back against me for the injury I did to you. You saw in the video that as we proceed, I can do discovery, and once I get evidence, I can do various motions to the judge saying, hey, I have this evidence, these such and such facts are not disputed, you should give me judgment anyway, judge. We don't even have to go to trial because I've already won based on the evidence if you just look at the law. Motion to dismiss, motion for judgment, I'll let you read through those. Summary judgment's the most common one, and that's where I've done discovery and I've said, Judge, you know, there are really only 5 sets of facts, I'm making the number up, that the law requires me to prove under this theory, this negligence, for example. I only have to prove these 4 things. Well, here's all the evidence. I got statements, deposition from the other side. We don't have a dispute. They did this, this, and this. They were looking down. They admitted they were reading their phone instead of looking, and they ran into me. The judge would probably give me summary judgment, in other words, without having to go to trial, saying, yeah, I'm going to give you judgment against them. They were looking down at their phone. That's negligent. You can see, I'll let you read through the various types of motions. Discovery we discussed, and again, we can find out things from each other if we're suing each other. We can take a deposition, which is like it's like a trial without the judge. The witness is in there, whether it's you, me, or maybe a witness to the accident. So the witness will be in there, a court reporter will be there and actually take down the testimony, often record it by video as well. And then that later can become evidence in court, the deposition. Interrogatories simply mean questions, written questions that we send to each other. Hey, you know, do you have insurance? Were you driving on this day? Were you, just different questions you can ask so you don't have to go to trial blind. You have all these facts taken care of before you ever get to trial. Same thing, request for admission. I might write to you and say, admit that you were looking down at your phone when you hit me. And I might have a police report where you already admitted that to the cop, or the policeman. Well, you may say, okay, I admit. So that's your response to my request for admission. We can also request documents, objects entered upon land. So if I sued you for damage to my car, then your lawyer should ask me for various documents, including the bill that I got from the auto repair shop. How much did it really cost? So for example, if I sue you and say, hey, my car repair was $50,000, your lawyer better say, look, give us the bill, and he finds out it's $300. Well, it's just that we think the documents are often the best type of evidence. If you can also ask for objects, let's say, for example, there's a product liability suit and you want experts to look at this object to see if it really was faulty. Or let's say you're suing about land. There was pollution on somebody's land. You can actually get the judge to permit you, or you can ask voluntarily through a request for entry upon land, to actually go see it, take pictures, and see, how bad you think the pollution was. Request for examination. You could actually, if I claim medical after, oh boy, some people call whiplash whipcash. Oh, I just can't move. Ever since you hit me going 1 mile an hour, I haven't been able to walk. So I want $100,000. Well, hopefully your lawyer would say, okay, I'm having a request for examination where you go into a doctor, not my doctor, not yours, but a doctor that will examine you and then give us a report about whether you really are hurt. Electronic discovery, just same thing when you're asking for documents or asking questions, the side whom you've asked. So if I'm sending interrogatories or requests for production to you, you also have a duty not just to give me hard copy things, but if things are kept in digital form, you have to also respond, having to do with the electronic or digital version. You see the different types. There'll be a pretrial conference, at least one, and the judge is basically going to say, hey, have we resolved some of these issues? What are we down to? How long is the trial going to be? How many witnesses? Blah, 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 blah. And the judge to see what we really have to try, or if he can get the parties to settle. So he'll often, or not him personally, but if he'll send you to a mediator or to another judge to try to settle. So those are the type of things we'll talk about with the judge at our pre-trial conference. Jury, yes, you have a right to jury trial in many instances. Most cases don't have juries. You just have a judge, but you can request one if you want. So you might have just a jury, you might just have a judge. If you just have a judge, it's called a bench trial, and the judge decides questions of fact and questions of law. Okay, what's a question of fact? What's a question of law? Let's try to keep this simple. You ran into me, and I say legally, or in other words, an issue or question of law, you were negligent. Well, the judge will decide a question of fact. The first fact is, you were looking down at your phone when you hit me in your car, and that's a question of fact. So he's going to decide that fact, and then he's going to say, because of that fact, I come to the conclusion, the legal or question or issue of law, that you were negligent. Okay? Now, in the same instance, if we have a jury, the uh, jury decides all the questions of fact. Theoretically, the judge decides the questions of law. How does he do that? The jury's going to sit there, listen to the evidence, and then after the witnesses are over, have completed their testimony, and before the jury goes into the room to deliberate, the judge will give them jury instructions, and that's actually the law. So he's going to say, you have to follow this law. Here it is, A, B, C. For Kevin to prove negligence, he has to prove 1, 2, 3, 4. And then the jury goes back and says, oh, did he prove 1, 2, 3, 4? If yes, then boom, we decide he has, and then the judge says, okay, we rule in favor of Kevin. Jury selection, I don't want to spend a lot of time on that, but basically a couple of concepts. The first is the lawyers actually get to go through and question potential jurors to decide if they want them or not. They have the right to strike or kick out or excuse jurors just if they don't like them, but they only have so many chances to do that. So basically, you're going to look at the jury, and each of you are going to want to have diametrically opposite types of jurors. The defendant's going to want to have this kind, and the plaintiff's going to want to have this kind. And so you each take turns striking off the people that the other one would want and you wouldn't want. And ultimately, you reach an agreement on which jurors will be there. The judge will excuse jurors, in other words, let them go. If, for example, they know one of you, they know either me or they know you, the people being sued, or they work for an insurance company, so they're biased because they don't want their insurance company to have to pay me for, this accident. I mean, there's different things where a person is considered, the risk of having bias is so high that they just won't be asked to be a juror. Let's get to the trial. Before we start hearing testimony of the witnesses and documents presented to the judge and/or jury, both lawyers are going to give their opening statement. This is what I think the case is, and then the other lawyer says, no, I think it's this. Then we'll start putting into evidence via everything from video to witnesses to documents, etc. And to do so, this really is beyond this course, but there are specific rules of evidence that I, as a lawyer, have to follow in order to get evidence before the judge or the jury. A couple of examples, relevant. You might have been wearing a green shirt when you ran into me. Well, if I start testifying about your green shirt and blue hair, because I think, oh, the jurors over 60, they're not going to like that. Well, that's not relevant. That really has nothing to do with whether you were negligent or what kind of a driver you are. So the judge is going to say, no, we're not going to discuss what the person was wearing. Hearsay, roughly, this is pretty complicated when it gets in practice, but roughly, we're going to get the best evidence we can. We're not going to hear, somebody say, hey, my cousin saw the accident. He said such and such happened. No, the person who was the witness and actually saw it firsthand, we're going to hear the testimony from him, not from someone who heard it secondhand or hearsay. That's a generalization of that rule. Once I get my witness on the stand, you've seen this in the movies. I'm going to ask him questions. The other side gets a chance to cross, and then I might have a chance to direct again, and the other person might, on the other side, might have a chance to recross. Just means ask questions again. That explained. The witness we talked about who saw the car accident is a fact witness. But there's also something called an expert witness, and that's a person who doesn't necessarily have firsthand factual knowledge, but they might be an expert. For example, um, a medical examiner who saw a body and after the fact and drew a conclusion that he saw stab marks here. Therefore, the person probably died this way. Um, in our traffic accident, someone's an accident reconstruction expert who looks at whether there's skid marks or not and sees if you hit the brakes. He even though he didn't see the accident as an expert, he can get up and say, "Hey, I went and checked the scene. There were no skid marks. So it is my opinion that the person who hit Kevin didn't even attempt to stop." So that's a very simplified example of an expert witness. We already talked about those judgments, or excuse me, the motions, except this one is actually during the trial instead of before. Uh, the jury comes back and votes one way. You can go to the judge. Wait a minute, the jury was a kangaroo court. It went way down off this way, and they should have decided this way. So you can move for the judge as a matter of that, or let's say the other side has not even provided evidence that would have met what they had to do, then you can actually just ask the judge for directed verdict before it goes to the jury. So there's a chance that the judge will decide it's not even going to go to the jury. You didn't make your case. Fairly rare, but it happens. Evidence. After all the evidence is on, of course, the two lawyers do their closing arguments again. Whether if just to the judge, or if to a jury, to the jury. We talked about the jury instructions that the judge is going to give to the jury. He'll read through them and then give them a hard copy of the jury instructions. Then the jury comes back with a verdict, or the judge does with a judgment. In civil cases we're talking about, they're going to basically say who's liable. For example, Kevin breached the contract, he's at fault. Or in the car accident, you're at fault because you ran into me. So that's the liability issue. And then the second thing the jury and or judge is going to rule is money. Is there going to be money awarded? How much was the car repair? Post-trial motions, again, there are things you can say, hey, the judge messed up. But most of the time, you don't go back to the judge himself and say, hey, you screwed up. You need to rethink this, because you're going to get a pretty bad response from that judge. It's usually better to just go to an appeals court. However, you do have this option. You see that. We talked kind of about that one. Now we get up to appeal. I'm going to let you read through the appeal and how one files appeal with an appellate court. These are what a court can do based on what it reviews, an appellate court. Now, let's finally talk about a writ of execution. Let's say that you get a judgment against me for $100,000. That doesn't mean I automatically pay you $100,000. You then have to go execute that judgment. So, for example, you could go to the sheriff and say, hey, seize his assets. You could go to my employer and a garnishment and say, hey, we have a judgment against Kevin, so we're entitled to some of his wages. You could go to my bank and seize my savings account, for example. So this is called enforcing the judgment or executing the judgment. And it's prudent to, before you spend all the time and money suing somebody, doing a little due diligence to determine whether they have any money or not. There's an old joke about some people that don't have car insurance don't because they're judgment proof. Even if you sued them, you couldn't get a nickel out of them. So that's one thing that you make sure you want to do. Okay, so that's all for this lecture. Thank you for listening.